Good evening, ladies and gentlemen. It is a great honor to be here, and I want to thank very especially the Kinder Institute for sponsoring this event, and I also want to thank my good colleague John Yu for this debate. We have debated each other a number of times before, and it is always a great pleasure. I have tremendous respect for John, and I have learned a great deal from him, from his very learned commentaries on executive power. And so it is in that context that I want you to understand that, number one, I will not make any comments about the size of his hands. And at the same time, I will very strongly disagree with some of his major arguments, even as I agree with others. Let me say three things at the outset, okay? First of all, I don't think this is a debate about executive power in the abstract, okay? I believe in a strong executive. I think that's what the Constitution intended, and had I been around in the 1790s, I would have been a Federalist, okay? So this is not about a strong executive. I believe in a strong executive. The question is, does that strong executive extend to having the power and the right on his own to place the United States in major foreign conflicts? And my answer to that is no. Okay? Secondly, this is not about arguing that every time the president uses force, the president needs congressional authorization. There are many Supreme Court cases, many instances in the past history of our republic in which there has been an acknowledgement that on certain specific circumstances, as I will discuss later, the president indeed can use force without having to get congressional authorization. Okay? What this is about is the proposition that whenever the president initiates force on a major scale, involving major expenditures in American treasure and in American lives, and places the United States at significant risk, in order to do that, the president must have congressional authorization. And it is on this key point that my honored colleague and I disagree very strongly. Okay, let me lay out my case in two ways, okay? First of all, okay, the Constitution as drafted and as ratified and as interpreted by those who were closest to it, by the generations not only who basically implemented it at the beginning of the Republic, but also in successive generations up to and beyond Abraham Lincoln, clearly believed that the president could not on his own put the United States in a major foreign war. Okay? So the people who drafted the Constitution, who wrote the document, including very different people, including people as different from each other as on the one hand Thomas Jefferson and James Madison, and on the other hand Alexander Hamilton, they did agree on this one fundamental point, that in order for the president to place the United States in a major foreign war, Congress needed to authorize that. Congress had to take the step. Okay? And then the second argument that I want to make is that in addition to the issue of faithfulness to the Constitution, okay, there is another reason for this. And it's the very simple principle of democratic accountability. In a system of representative government, it should not be the decision of a single person to decide whether to place the entire country at war with all of its attendant risks. We may want to have the president, of course, authorize uses of force when the United States is attacked and there is a need for an immediate response. On this, there is no controversy. But whenever the president is contemplating, deliberating, placing the United States in a major conflict in which the lives of thousands, even millions of Americans will be at risk, and billions and even trillions of dollars could be spent, that decision as a matter of democratic principle should not be made by one person. It should be subject to the deliberation of the people's representatives, which, according to our system, include and constitute fundamentally the Congress of the United States. Okay? And on this issue, of course, Professor Yu and I have this disagreement, which to me is very curious because Professor Yu writes very much from an originalist viewpoint. He's a close student and a great admirer of Justice Antonin Scalia, the father of originalism. So you would expect Professor Yu in his writings to reflect on this particular issue a very close reading of the Constitution. But I think what is interesting is that, as you will see shortly, he's not an originalist when it comes to this issue. Okay, so let me just read to you some quotations, okay? And they're not out of context. Some quotations from the founders, from the people who wrote the Constitution, who argued about it, and who implemented it immediately when it was put into effect, okay? So here it is, okay? James Madison, okay? In the Helvidius debate in 1793. And James Madison is making a distinction between two different things. Okay, as we know, the Constitution makes the president the commander-in-chief of the Army and Navy of the United States. And I always tell my students that because I say to them, the president is not my commander-in-chief. Okay, so the president is not the commander-in-chief. He's the commander-in-chief of the Army and Navy of the United States, of the armed forces. Okay, he's not the commander-in-chief of the citizens. He's the commander-in-chief of the armed forces. But Madison is saying, okay, yes, the president has this authority as commander-in-chief to command the armed forces, but that is not the same thing as the power to get us into a war. Two very different things. And so Madison writes, instead of being analogous to the power of declaring war, it affords a striking illustration of the incompatibility of the two powers in the same hands. In other words, he's saying the two powers, commander-in-chief and getting the country into a war, should not be in the same hands. Okay? They should be in separate hands. He says, those who are to conduct a war, the president, cannot in the nature of things be proper or safe judges whether a war ought to be commenced. They are barred from the latter functions by a great principle in free government, analogous to that which separates the sword from the purse or the power of executing from the power of enacting laws. Okay? So that's a major point where he says, yes, the president is the commander-in-chief. Precisely because of that, the president cannot be the person who decides when we get into a major war. And he develops this in great detail. He says, war traditionally is the spring of patronage. It is an instrument for executive aggrandizement. So we don't want presidents starting major wars on their own because wars do tend to increase executive authority. We need some other power to make that decision of when the country should go to war. Okay. He adds, in no part of the Constitution is more wisdom to be found than in the clause which confines the question of war and peace to the legislature, not to the executive department. And I want to stop here for a second and suggest that, Professor Yu, when he reads the Constitution, we have on Article 1, this section that says, Congress shall have the power to declare war. And Professor Yu argues, well, this power to declare war is not the same thing as making the decision and authorizing only when war should be started. He says, in 18th century, declarations of war had the purpose of announcing to other states that the United States was not legally in a status quo war and that certain rights and obligations flew from that. So it is an announcement to the world. And he also makes a very good observation that, of course, there have not been declarations of war by the United States since December of 1941, and that therefore we cannot say that a declaration of war by Congress is the only way by which the country can get into a war. My argument is that the declaration of war in the 18th century and subsequently was viewed as involving two things. It did involve, indeed, a declaration by Congress that a new legal status was now present, that the United States was at war and that therefore certain rights and obligations flew from that. But it was also an authorization to the president. It was the means by which the president was authorized and by which the country was put in the state of war, as we will see very soon from Alexander Hamilton. Okay? So Again, going back to Madison for a moment, hence it has grown into an axiom that the executive is the department of power most distinguished by its propensity to war. Hence, it is the practice of all states, he says, in proportion as they are free, to disarm this propensity of its influence. How? By putting the power to place us into war into the hands of another co-equal branch. Thomas Jefferson, okay, from a letter to Thomas Jefferson from James Madison. The Constitution supposes what the history of all governments demonstrates, that the executive is the branch of power most interested in war and most prone to it. We know that from history. It has accordingly with studied care vested the question of war in the legislature. In a very famous letter to Madison, Thomas Jefferson said this: we have already, he's referring to the Constitution, he says, we have already given in example one effectual check to the dog of war by transferring the power of letting him loose, okay, this dog of war, from the executive to the legislative body. Notice, the power of letting war loose has been transferred from the executive to the legislative body. And this is, of course, because under the British Constitution, okay, the executive power, the king, okay, had the power to place the country into war. Okay? Parliament had no power over that. And the king, of course, had extensive foreign relations powers, including making treaties and placing the country into a war. Now, here we come to Alexander Hamilton, okay, the great father of doctrines of executive power in the United States, and somebody that, Professor, you and I admire considerably. So he's a very credible source for me, because Alexander Hamilton very specifically says, this is the difference between us and the British Constitution. In Great Britain, the king is commander-in-chief, he makes treaties, and he places the country into war. Under our system, however, he says, the president also is the commander-in-chief, the president makes treaties, with the advice and consent of the Senate, but the president doesn't put the country into a war. Congress does that, okay? And President Washington, okay, our first president, understood that very clearly. This was, I would argue, this is like mother's milk to this entire generation. This is what Washington said in a letter to Governor Moultrie. The Constitution vests the power of declaring war with Congress. He adds, therefore, no offensive expedition of importance, okay, can be undertaken until they, the Congress, have deliberated on the subject and authorized such a measure. So the language of authorization is already back then, in the 1790s. It is not something that Congress has added in the post-1940 period. Already in 1793, Washington is saying only Congress can authorize this. Okay? Look at Chief Justice John Marshall. Okay? Again, part of that founding generation. Okay? In Talbot versus Seaman, 1801. Okay? Marshall was an aide-de-camp and a close friend and confidant to George Washington, became one of his protégés. Washington urged him to run for Congress, and eventually, of course, Marshall was Secretary of State and appointed Justice of the Supreme Court. The whole powers of war, this is John Marshall, 1801. The whole powers of war being, notice, the whole powers of war, being by the Constitution of the United States vested in Congress, the acts of that body can alone be resorted to as our guides in this inquiry. Congress alone is constitutionally invested. Congress alone is constitutionally invested with the power of changing our condition from peace to war. That is, from changing the country from a state of war, from a state of peace to a state of war. Okay? And so Alexander Hamilton, of course, lots of language, very in a letter that he wrote as Lucius Crassus, he writes, the Constitution, okay, shall have power, okay, under the Constitution, Congress shall have power to declare war. The plain meaning of which, says Hamilton, is that it is the peculiar and exclusive, no one else has that, exclusive province of Congress when the nation is at peace to change that state into a state of war. Okay, so again, it's not just a matter of declaration of saying to the world, well, hey, we are now. It is changing the country from a state of war to a state of peace. In other words, Hamilton here, these are Hamilton's words. In other words, it belongs to Congress only to go to war. Okay? So my argument here is that this is how the leading architects of the Constitution read the text. Our first president and succeeding presidents read the text, and that this was, of course, not just a matter of originalism. You don't have to be an originalist. You don't have to be an admirer of Justice Scalia's philosophy to also understand the underlying principle here, which is that in a society of free men and women, where we have representative government, this momentous decision should not be made by a single individual. It should be made by the people's representatives.
Thank you, Professor Coll. Professor Yu will now turn it over to you for a response.
I'd like to thank you all for coming tonight, and I'd like to thank Professor Dyer especially and the Kinder Center. It's really neat to see what a university with money actually looks like. being at Berkeley, you know, it's a big, nice change to be in a facility where there's not trash on the ground and homeless people in the classroom, except for the graduate students, of course. It's a really great pleasure to be here. I also want to recognize Professor Dwyer has great influence with the country, because it was very kind of him to schedule the primary here in Missouri to take place right before our debate on presidential power, so that we could have immediate interest. Although I have to say now that it looks like Donald Trump's going to become president, I'm going to reconsider my views on the extent of executive power in the American presidency. I'd also like to say thank you to Alberto Coll, who, as he said, we've done several different debates in different fora about various aspects of war power, and it's always a wonderful pleasure to debate him. I do have to warn you that he does not have the typical life and background of a law professor. He's, you know, just while we're driving over, he was telling stories about walking in downtown Havana, and he's in the Pentagon. He's also not just a lawyer, but he's also one of the almost no law professors I know of who combine being a law professor with being a strategist about national security. So this is true, Alberto. It doesn't go to your Cuban Hispanic heritage, but whenever I see that guy, the most interesting man in the world commercials, in my mind, I always think, but even though he doesn't have the big beard and everything, he has that kind of mysterious lifestyle that you see in the beer. I've only seen a beer commercial. So let me turn to the serious matter at hand. So just to start, I have a lot of respect for Justice Scalia. I am an admirer of his work and his approach, and I am going to try to follow it, actually, in the way we discuss it. It might be interesting, since the president just announced the nomination of Merrick Garland today. We could talk about in question and answer what that might mean for the Supreme Court or on the war powers question. But I think before you get to that, there is an agreement, not just amongst me and Alberto, but actually amongst most professors, that the answer to the question of who has the right to start war really should be sought in the 18th century and the original materials from the Constitution. It's a very strange area of agreement. It also took place with the Second Amendment. For those of you who followed the Supreme Court cases about whether the Second Amendment guaranteed an individual right to bear arms, both the, you would call them liberals in dissent and conservatives in the majority of those opinions, also all spent all their time arguing about what did bear arms essentially mean in the 18th century. Part of this is because I think this is an area where the practice of the government is sharply divorced from what many scholars, I would say most scholars, think is the original meaning of the Constitution. I'm going to argue tonight that that view of the Constitution is mistaken, but if it were true, if the professors were correct, then Alberto and I probably would agree that this part of the Constitution might be the one that's most violated by the government on a regular basis, because in terms of practice, the United States has only declared war 5 times. It has used force abroad around 140, 150 times, ranging from small rescue operations to big wars, like all the wars after World War II. To me, however, that suggests that there is a high level of agreement between the branches of the government, between the president and the Congress, regardless of the personalities involved, regardless of which political party has occupied either control of either branch, that suggests that they don't think that this reading of the Constitution that Alberto put forward is the correct one. Presidents of many parties over many years have claimed the right to start hostilities without a declaration of war, and Congress, which has plenty of tools at its disposal to stop wars and to stop presidents, have never used them. They've used them in a few examples which I think are more consistent with a different reading of the Constitution, one based in the funding power. One last point is, I think, in terms of the practical effect, is that it does sound attractive, Alberto's argument that wars are terrible things for our country, and so this is Jefferson's view. Jefferson had the phrase, we should clog up the path to war by making as many people responsible. Many people have to turn the key, right? If you think about Alberto's model or Jefferson's, I'll call it the Jeffersonian model. It's almost like the submarine with the nuclear weapons. Both the president and the Congress have to turn the key simultaneously for there to ever be a war under their view of the Constitution. This is obviously a system that makes sense if you think the United States makes more mistakes by going to war. What political scientists, which many of you are studying to be, would call type 1 errors. You make an error of commission, right? You do something that's a mistake. But social scientists will tell you there's a whole other kind of error. Type 2 errors, they call them, mistakes that you make by not doing anything. And so if you thought that the United States, when it goes to war, is more prone to make mistakes, then you would want the Jeffersonian Coll system. If you thought, however, that the main threat to the United States might come from inability, from inaction, then actually the system that they describe would make things worse, not better. So that's something to keep in mind as you hear the various evidence. So when Justice Scalia or people who have followed him in the years since start to approach any constitutional question, they start with 3 things: the constitutional text, the structure, and its history. So let's look at the constitutional text. As you know, the Constitution, I actually just reached for it and I didn't bring it. And it's well used because every time Donald Trump says something, I go, he couldn't have said that, because in here it says something different. And we're going to be happy to talk about his views about immigration, the natural born presidency, all this stuff. Anyway, my Constitution is actually getting quite threadbare because of him. But I didn't bring it along with me. But I have it on my iPhone, so it's just as good. So the president is the commander-in-chief, and he's vested with the executive power of the government. Right? Congress, it has a lot of the war power that used to be combined in the British Crown. The Congress has the power to raise the military, to fund it, to declare wars, and to set the rules of capture, they're called. Interestingly, the Constitution does not set out a process for how those powers are supposed to be used, which is very different from other actions of importance that the Constitution regulates. The Constitution has a lot of provisions about exactly what order a statute goes through. Right? It has also a similar process for a treaty, or we're talking about now, confirming a Supreme Court justice, step by step. It's interesting, when it comes to war, there is no step-by-step process. It doesn't say that Congress has to declare war first, and then the commander-in-chief power is triggered. This is essentially the argument, aside from the question of immediate surprise attacks, where we agree. There's another provision of the Constitution which Alberto didn't mention. Most scholars don't look to. I claim to have found it. I didn't find it because it's always been there, but no one thought it was relevant. So this has got to, for those of you who are graduate students, when you want to make your name in scholarship, this was the very first article I read. And I wanted to examine the claims about the war power. So what I did is I looked in the Constitution, and I looked up every time the Constitution used the word war. And no one had done that before, strangely. And so I found this provision in the Constitution that heavily regulates war that no one had ever written about, because it applies to states. And this is in Article 1, Section 10 of the Constitution. If you have a Constitution handy, go take a look. And it says, no state shall engage in war. It doesn't say declare war. It says engage in war without the consent of Congress, right? Without the congressional approval. It doesn't say unless Congress declares war, right? It says no state shall engage in war without the consent of Congress. And then it even has the clause, the exception that we agree has to be there, but it's not in the text, unless the state is actually invaded or is under emergency circumstances, essentially. This is exactly the system that Jefferson or Madison or Alberto believes governs the federal system, the president versus Congress. So the obvious question is, why didn't the framers just repeat that provision? And instead of saying states, put in the word president. It also flies in the face of a common rule of constitutional interpretation, which is you should read every word to have a meaning. And so if the Constitution uses different words in different places, you should read them to have different meanings. The second thing, so the implication for me would be that declare war does not mean begin war. That would be engage in war. It doesn't mean Congress has to give its consent, because in other places they talk about how Congress gives its consent. So to me, the implication is that the Constitution leaves it open for the president and the Congress to struggle with each other, to use the powers they have to fight over who gets to start war. And so sometimes the president will have the upper hand, sometimes Congress will have the upper hand. Sometimes in our history that has been true. Sometimes Congress has been the dominant body in our foreign policy, sometimes not. Second, the structure of the Constitution. If Professor Coll, if Thomas Jefferson were right, why bother having a president? You don't need to have a president. We could become like a British parliamentary democracy. If Congress really had the full power to decide when to wage war, then they could decide when to wage war, and they could appoint a commander-in-chief for each war. Right? There's a reason the framers did create a president. It was actually, if you think about it, a unique and unprecedented act for the framers even to create a presidency, especially after they had rebelled against having a British king. And the reason they created that presidency is because they understood that there would be circumstances, situations, crises, emergencies, ultimately war, where you needed one person, always part of the government, always in existence when Congress was not. Believe it or not, the framers thought Congress would not be meeting most of the time. And that, if you remember, they would have to come from all over the country and basically on horses and buggies to meet. And so there had to be someone always in charge, always able to act, able to react to unforeseen circumstances. If Congress could anticipate every future circumstance and write a law to prepare for it and to appoint people to take care of it, you would not need a presidency. This was the framers' insight. This is an idea of a justification of executive power that goes back from the framers to Montesquieu, to Locke, to Hobbes, to Machiavelli. It's a professor Harvey Mansfield who sort of originally traced the lineage of this idea. And so the framers also talked about and debated, should we have two people, like the Roman consulship, or one person in charge of the executive branch? I have to say my original home state of Pennsylvania was a terrible state in terms of constitutional design. The governorship at the time of the Constitution in Pennsylvania was 12 people who were elected for one-year terms and had to leave office after the 1 year and could never hold office in the governorship again. Sounds like the Tea Party in a way, doesn't it? And the framers reacted against all those experiments at the state level. They said the presidency has to be one person so the president can act quickly, decisively. They wanted there, as the framers said, to be energy in the executive. On the other side of things, and this gets into the history, Congress was to have control over war through the power of the purse. If you go back and think about American wars before World War II, this was a complete check because the United States never had a standing army and navy. We had forces that patrolled the border, maybe small expeditionary forces. We did not have anything like the military we have now. And so every time a president wanted to go to war, he would have to go to Congress and say, please build me an army and navy to fight this war. And so Congress could easily stop any war it wanted to just by never funding it in the first place. That changed after 1945. We now have this military that's larger than all the other militaries of the world put together in terms of spending. We have a military that's designed, all those aircraft carrier battle groups, all the army, the tanks and the helicopters, those are all designed, if you think about, to fight wars in other people's countries, right? Not to fight them here. Those are all built and paid for by Congress. Congress doesn't have to design a military that is really solely prepared for offensive operations. We do not have a defensive military. We have a military that's designed for one thing, that's to carry out offensive operations abroad. If Congress did not want to have presidents waging war, they could have designed a military that looked very different than what does now. That goes back to my point. This is an area where the presidents and Congress actually, in terms of practice, seem to me to agree on the way war should be fought today. Lastly, because I know I'm running out of time, in terms of the history, this debate did come up. I'm looking forward to debating with Professor Coll some of the quotes that he read out to you, although I will point out that many of them come from the period of time after the Constitution, during a time of very heated partisan debate. You think things are bad now with Donald Trump and Marco Rubio arguing about the size of body parts. You have no idea compared to like Jefferson and Hamilton and Madison said even worse things about each other. I saw you have a Jefferson statue on campus that gets decorated in, shall we say, creative ways. The accusation that Jefferson had fathered a child with his slaves the evidence for that comes from accusations by his political enemies in the time that were published in the newspapers. So this last point is, during the Virginia Convention, when the Constitution was debated and almost lost by 4 votes out of 160 delegates, Patrick Henry got up and he said, "You have created a constitution that creates a dictator, a military dictator," in very similar ways to what Jefferson was saying. And James Madison got up and said, "No, that's not the way it is. Under the Constitution, the president has the power of the sword and Congress has the power of the purse. That's the way the parliament controls the king in England, and that's the way the president is controlled here under our Constitution." So thank you very much, and I look forward to the rebuttal and to your questions and hopefully our answers. Thank you.
Professor Coll, you have 5 minutes for rebuttal.
Professor Yu just gave you one of the most powerful arguments for the dangers of the position that he espouses. He has reminded us that today, unlike decades ago or centuries ago, we have a permanent military establishment. In other words, literally, presidents can go to war anytime. Okay? So if Hamilton and Jefferson, by the way, who were on opposite political parties, who hated each other, but nevertheless agreed on this one point, that the question of putting the nation at war belonged with the legislature, while the question of fighting the war and being the military commander-in-chief belonged to the president. Their view was that it is dangerous in a republic to give the power to the president to make war. If that was the case back then, when Congress could fund the military and could say, we're not going to have a military, or we're going to have only 10,000 troops, it is even more dangerous today to give that power to put this country in a war to the president, because the funding authority by Congress is largely meaningless for 2 reasons. Number one, because we have a permanent military establishment. We need it for strategic reasons. It takes too long to build military forces, so we cannot wait until we have a threat to build these forces. But also the second reason, which is people in Congress don't want to be tagged as not supporting the troops in the field. So they will reluctantly vote for these appropriations. Okay? Now, again, let me go back to Hamilton. Okay? And here he is. Okay? It is the province and duty of the executive to preserve to the nation the blessings of peace, but the legislature alone can interrupt them by placing the nation in a state of war. Again, this was the contemporary understanding. Justice Joseph Story in 1833, in his commentaries on the Constitution of the United States, it's the best commentary written on the Constitution of the United States. he develops this argument beautifully. He says, war in its best estate never fails to impose upon the people the most burdensome taxes, personal sufferings. It is always injurious. It involves the prosperity and not infrequently the existence of the nation. Okay? And then he says the power of declaring war is not only the highest sovereign prerogative, it is in its own nature and effect so critical and calamitous that it requires the utmost deliberation. Okay? So it should therefore be difficult in a republic to declare war but not to make peace. Okay? He calls it the highest act of legislation, putting the country in a war. Okay? And then finally, Abraham Lincoln, okay, in his very famous correspondence with his friend and law partner, he says the provision of the Constitution giving the war-making power to Congress was dictated by the following reasons, which are just as relevant today, almost 200 years later. Kings had always been involving and impoverishing their people in wars, pretending generally that the good of the people was the object. This our convention understood to be the most oppressive of all kingly oppressions, and they resolved to so frame the Constitution, again, that no one man should hold the power of bringing this oppression upon us. So, I think that we do have a very strong argument for a strong executive. The executive is in charge of the conduct of military operations. We also have a strong argument for why the presidents need to be able to respond when this country is attacked. Okay? But we also have the text of the Constitution and the way in which it was read by the people who drafted it and people who disagreed with each other on many issues. The Federalists and the Democrat Republicans, Jefferson's party, disagreed so violent, as John pointed out, so partisanly on so many issues, but they did agree on this one issue, that Congress needs to be the body that places the country from a condition of peace, as Hamilton puts it, to a condition of war. And I think that this is only reinforced by the fact that in our times, okay, the consequences of war can be so calamitous that they need to be deliberated on by the people's representatives. I think to go down in a different path is extremely dangerous. And it would basically put the President of the United States right in the place where the kings of the 18th century stood, which is the very opposite of what the Constitution intended. In the 18th century, kings could place their nations in a state of war and argue all kinds of national security reasons for it. But I don't think we want to go back to that model. And we want to have a model in which, yes, the president has very broad executive powers. The president can collect all kinds of intelligence on all kinds of foreign sovereigns. He can carry out very extensive activities in defense of the national interest. But when it comes to an issue involving placing this country in a major conflict with large risks, human, financial, and strategic, that should not be done by a single person. And I should add, finally, as a closing point, that this argument makes particular sense, okay, at a time when we are trying to determine which way our democratic society will go in the future. It is time for us to remember that even though Congress often can be politically very lazy and refuse to live up to its responsibilities, Congress has occasionally stepped up to the plate, and that in both Iraq interventions, for example, whatever you think of them, Congress authorized the presidents in both cases to place the country in a major war against a foreign sovereign. Thank you very much.
Thank you. Professor, you have 5 minutes.
So this is not a debate about whether it's a good idea to have Congress participate in war decisions. I mean, I think if there's time, I think the president obviously should consult with the Congress. When I was working in the Bush administration, even though I have this view, I did advise the White House that it would be a good idea to get Congress to vote for both the Afghanistan and Iraq interventions to have to reflect the unity in our political leadership about whether war is a good idea. But I'd also say that just because it may be the case that Congress chooses not to use its powers that I've described, the funding power, the power of the purse, power to create and build the military, doesn't mean the Constitution is somehow defective or we have to change the reading of the Constitution. It just means that Congress doesn't want to use the power that it can to stop the president. Congress has done that from time to time. Those of you who remember the Vietnam War ended because Congress cut off all funds in Vietnam. The second point I just want to make is Alberto has a good point in that what is the purpose of a declaration of war if it isn't to start hostilities? I think there's a difference between starting a hostility, initiating hostilities, what the framers would have called it, and declaring war. In the 18th century, to me, declaring war meant, as many of the quotes that Alberto read indicate, changing the status of the country from one of peace to war, changing the relationship between two countries to one of a legal war, which was different than just hostilities. And one reason to think this is if you look at British practice for the 100 years before our Constitution, there were no declarations of war. There was maybe, I think, one declaration of war in British history in this period before hostilities actually started. Usually, Great Britain would be at war, sometimes for years, with other countries before a declaration of war ever issued. There was no idea under the British system from which we got a lot of the terms we use in our Constitution, like declare war, like commander-in-chief. Those are all British terms from their constitutional system. That system did not seem to think that declare war meant start hostilities. In fact, if you want to read a great declaration of war, you have one next to your Constitution. It's called the Declaration of Independence. If you look at the Declaration of Independence, it's actually a declaration of war. A declaration of war back then would say, here are the reasons we're angry at you. This is what we're going to do to you because of it. And if you want the war to stop, this is what you have to give back. They're almost like a legal complaint in litigation. If you remember our history, the Declaration of Independence is issued on July 4th, 1776, well after hostilities break out between the colonies and Great Britain. There's no idea that the Declaration had to mean start. So let me just run through some of the quotes that Alberto read out to you in his initial presentation, because I think they actually conform to this other meaning of declaration. So the first one he gave you was from James Madison in the Helvidius Pacificus debates. Now those I tend to discount as a tool of interpretation because they come several years after the ratification of the Constitution. They're about the Jay Treaty, which is the second effort to make peace with Great Britain at the beginning of Washington's second term. And this time period is so partisan, so much more partisan than the one we have today, was so polarized is the fancy term, that it led to the founding of the Democratic Party, the first political party in our history. And James Madison did have the view that Alberto set out. He thought that the president has no authority to declare war or even to declare peace. Madison was arguing there in favor of the idea that the president could not even declare neutrality. Most historians, constitutionalists, think that Madison was utterly wrong and that the Neutrality Proclamation was constitutional. Otherwise, you have to think that the Constitution also gives the Congress the lead authority in all foreign policy matters, even though from the beginning with George Washington it hasn't. His second piece of evidence, Thomas Jefferson's letter saying, we should stop the executive. The executive is the one that always self-aggrandizes itself. You should remember, Jefferson was a critic of the Constitution. He wasn't even here during the ratification of the Constitution. Where was he? He was having a good time in Paris, right? Collecting library heritage wines and shipping them back to Monticello. God knows what else he was up to over in France. But one thing he was not up to was working on the Constitution, because he was not part of the ratification. In fact, several of the Federalist Papers anonymous, don't name him, but criticize him because they thought his views on the Constitution were flat out wrong. You might remember he also wanted us to have a Constitutional Convention every 18 years and write a new one, right? Which the framers in the Federalist Papers thought was actually anti-constitutional in its very nature. I think Alberto's best point is the Hamilton quote he read you from Federalist number 69, where he's comparing the British king to the American president. He says the British king has the power to declare war, raise the army, and make war, to be commander-in-chief. He says the American president only has the power to be commander-in-chief. I agree. The power to raise militaries and to fund them is transferred from the British Crown to the Congress. The power to declare war is transferred from the Crown to the Congress. But Hamilton never says what the declare war power is in that list. He's just contrasting the two. He never says the power to declare war is the power to start hostilities. And then let me end with George Washington, who I agree should be, he's not someone who's often mentioned when it comes to the framers, but ought to be. It is true, as Alberto said, that he wrote a letter after he became president to a governor saying, Congress should decide on war and peace. But when he was president, he launched a war against the Indians without any authorization from Congress. This was, at that time, the worst military defeat in our history. The American army, in total, at that time, was completely wiped out. And Washington did not ever seek authority from Congress for the very first, this is the very first war, actually, in American history under the Constitution. He just started it with the troops that he had authorized by Congress. And after the great catastrophe, it's called the St. Clair Expedition, he went back and just asked Congress to build another army. And then he went after the Indians again. There was never a declaration of war. This is not one of the 5 declarations of war that the Congress has issued in our history. So although Washington might have said that to a governor, in practice, I think like a lot of these framers, like Jefferson and the Barbary Pirates, for example, in practice, when they were actually exercising executive power, they did not seem to think that Congress's approval was necessary. Thank you.
Thank you both. We'll now open it up for questions from the audience. And as I mentioned earlier, please do keep your question to a briefly stated question so that we'll have time for plenty versus maybe a longer statement. I'm going to kick us off with a question and then we'll head on out to the audience and see what questions you have for our debaters. Given your emphasis on history, and this is a question for both Professor Coll and Professor Yu, what is the most compelling piece of evidence that you have come across that supports your opponent's argument on this topic rather than your own?
Okay, I don't have any problems answering that one. I think that the most compelling evidence in support of John's reading is that actually, especially in recent times, many presidents have gotten us involved in some major military interventions without congressional approval, but I should say on the really big ones, okay? And the one exception was the Korean War. In other words, when George W. Bush invaded Iraq, he had congressional authorization, okay? When George H.W. Bush went into Kuwait, he had congressional authorization. So, and the Vietnam War, you have the Gulf of Tonkin Resolution, which, however much liberal Democrats may want to clean their hands from it, very specifically authorized the president to do whatever was necessary. So that was authorized by Congress. World War II, World War I, we had declarations of war. So when we talk about major wars, what's one glaring exception? I would say the Korean War. And there, that was a weird argument put forth by Dean Acheson, in which he said, well, we're doing this as a UN operation. The UN Charter basically allows us to do this. We don't need to get congressional authorization. It was very heavily contested, very vigorously and very eloquently contested by Robert Taft, who I think unfairly is often accused of being an isolationist, but he wasn't. And he said, look, the United Nations Charter does not enable us to circumvent the Constitution. So in order really for John to make his point, he has to go what I call minor military operations, okay? And on that record, yeah, presidents do engage in these seemingly minor military operations. I mean, his example from Washington is a perfect example. This attack against the Indian tribes, Washington saw it as basically an exercise of self-defense. I mean, there were acts of violence taking place in these areas of the country. He sent the troops out there to quell these acts of violence. So I don't think this was by any means a use of force that was putting the young United States at major risk. This was not war with France or war with Great Britain at the time, and it wasn't going to risk, I mean, there was a defeat, a military defeat, but it wasn't risking lots of American lives or huge amounts of American treasury. So I think Washington saw it, what we would call in today's language, an exercise of self-defense in response to attacks and violence on the other part. So I'm willing to grant him that there's been a lot of executive practice, but I'm not willing to grant him that it has taken place with regards to the really big ones. Even though he is right that presidents very arrogantly, especially recently, have acted as if they don't have to get congressional authorization. And John's verb was very telling. He talked about consulting. We consulted Congress. But the Constitution doesn't say anything about consulting Congress. Now, George Herbert W. Bush and George W. Bush saw themselves just consulting Congress. They really believed they didn't have to do that. However, they thought about it, they did wind up asking Congress, and Congress wound up authorizing it.
Professor Yu?
So I'm reluctant to answer this because then Alberto will use it in the next debate. Especially because my answer is going to be his best stuff is stuff he hasn't even used yet. But I think he just mentioned at the end of his presentation, there are these Supreme Court cases from the early 19th century that do say things like, well, Congress has the power to declare war, so they have the petitions say things like, the ultimate decision on war is with Congress. These are all weird cases. They're cases about what we would call prize. They're cases where an American ship seizes a foreign ship and brings it back to the U.S. and the captain wants to keep it, which is how we paid our naval. I think we should go back to that, by the way. But naval officers basically made their living by capturing enemy ships and bringing them home and selling them. And so it would depend on whether we were at war or not with that other country to decide whether the captain got to. And there's dozens and dozens of Supreme Court cases about this, which have not been widely studied. If there's anyone out there looking for a paper topic, studying these cases would be a gold mine because no one's ever systematically read them and tried to figure out how these rules work. But in those cases, he mentioned one, Talbot versus Seaman, the court says, yeah, the Congress gets to decide whether at war. So if you seize a French ship and Congress hasn't said we're at war with France, then the Navy captain has to give the ship back to France. So those are very interesting cases, but it's hard to use them because they're not really part of the framing. They're part of the system of government that was created by the Constitution. But I think that's also an area where a lot of people who agree with Alberto also don't use these cases. So no one's really systematically looked at them. We didn't mention, but we should, that the Supreme Court has actually never really decided this question, one way or the other. And so that's another reason why we are having this, might be seemingly historically dry argument about the 18th centuries, because the usual precedent, Supreme Court opinions, things like that are not present to guide us.
Okay, thank you.
Both of you in your opening remarks conceded, probably out of common sense, that of course the president can defend the nation if attacked by a foreign nation, which evokes this dichotomy between offensive and defensive, which probably made a lot of sense in the late 18th century and much of the 19th century. But in the 21st century, where military technology and intelligence about what possible foreign enemies are doing sort of overwhelms that dichotomy between offensive and defensive, such that a president can attack a foreign nation clear on the other side of the world because it's believed that that foreign nation has weapons of mass destruction, and therefore were legitimated because those weapons might somehow be used, if not against us, our allies, and therefore an offensive attack, or what looks like offensive, can be justified as really defensive. So hasn't the military technology and intelligence really overwhelmed the whole nation, or notion of who's going first, such that the president in the 21st century can always go first and then later ask Congress?
I tend to agree with your question and its assumptions that you might have noticed. What Alberto is doing is trying to use history to set the Constitution system as fixed, and that so if there's this offensive defensive distinction, which is I totally agree with, is in the Constitution from the beginning. The Constitution actually originally said Congress has a power to make war, and then we didn't get to this, but in the Philadelphia Convention, the framers changed it to declare war. And they said, because make war makes it sound like the president can't even defend an attack. So we got to at least change that, which I think causes problems for the other side's interpretation. I'm using these historical sources to actually show that the Constitution is more, and this Justice Scalia would not like, is more adaptable to current circumstances. That what the Constitution did is it set out powers for each branch and then expected them to struggle, but that would also allow the war-making process to change based on things like new technology. And so if, as you're quite right to say, as the American view of what's a threat to the security of the country has gotten broader, that would allow the system to change. So Congress, in my mind, this happened since 1945, not just since 2000, September 11th, 2001. And so because of this idea that threats from abroad can occur faster than we could build an Army and Navy, the Congress pre-builds the Army and Navy and lets the president use it. That is undeniably a shift of power to the executive that Congress wants. I don't think the Constitution has a fixed rule that says Congress can't do that. I think Alberto's reading is such. He thinks that this offensive-defensive distinction and the ideas that the framers had actually was an effort to straitjacket the government into only making war in one specific way, regardless of what the current circumstances are.
I think your question has some good points, but it also has limitations. In other words, not every major military or strategic issue facing the U.S. is this kind of emergency preemptive attack against some nation getting ready to attack us, okay? That could be the case, okay, in some circumstances. For example, if the president tonight received intelligence showing that the Chinese or Russia are planning to launch a massive attack against the United States, obviously the president under the Constitution would have the authority to respond preemptively. If the intelligence is there, he would not be able to call in Congress and ask for authorization. But let's face it, not all the challenges to our national security are of that type. So, for example, you have the war in Iraq against Saddam Hussein, the second one, the bad one. There was clearly plenty of time to deliberate. No one was making the case that Saddam already had these weapons of mass destruction and that he or some terrorist allied with him was about to launch them. It was more the case he's got the weapons of mass destruction, we got to do something about it. Congress could have deliberated. In all fairness, Congress did deliberate and authorized the president to take whatever measures the president thought necessary. And so, similarly, you could let's say you could look at Iran today, okay? And let's say that we have evidence that Iran is about to develop nuclear weapons, okay? Well, the fact that Iran is about to develop nuclear weapons doesn't mean necessarily that it's going to launch them against us, okay? And again, so there would be time for Congress to decide whether indeed it wants to authorize the president on this major, risky and very costly operation of attacking Iran preemptively. So, there are times when there's a proper role for Congress, but there are always the emergency situations brought about by technology where there may not be time. I'll grant you that argument, but I also want to make it very clear that's not going to define every single situation that we're going to face in the future, and it does not do away 100%, or I would say even 50%, with the constitutional requirements.
Jay?
One of the defining characteristics, it seems to me, of war in the 21st century is war is waged against non-state actors, which raises questions like, against whom does one declare war? So I'm curious how that might inform your arguments. Professor, you mentioned, for example, the Barbary Wars, which strike me as the closest historical analogy to that. But it strikes me that the nature of warfare in the 21st century against non-state actors raises some incredible limitations for Congress in terms of the ability to engage in these debates, or not.
I don't agree with your premise. I think that when you look at the Declaration Clause, especially when you read in the context of how people at the time read it, it's not just a declaration against Japan, okay, of war. It is also an authorization to the President of the United States to prosecute a major war against Japan using all of our resources, okay? And so similarly, the issue, I don't care whether ISIS is or is not a state, a nation state. The declaration of war is not just about that. It's about authorizing our president to take very extensive actions against ISIS. Now, in the case of ISIS, we could get into that, what that issue is. But again, if we had a major terrorist movement out there, declaration of war is not about just declaring war on them. It's also about authorizing the president to do certain things so as to make sure that the people's representatives have had a say-so in putting the country in a situation where we're risking a lot. We're loading a lot of risk, okay? And we don't want that decision to be made by one person unless it's your emergency situation in which there's no other choice. Yeah, you've got the intelligence, the nukes are about to be launched against us in an hour, 2 hours, who knows, a few hours. Then, of course, that's the exception.
I think declarations of war have become obsolete in a way because most wars we fight against other nation states we claim they're defensive, and so you wouldn't need one. I think even Franklin Roosevelt didn't think he needed one after Pearl Harbor, but he wanted one to rally the country around. And that a lot of the threats are coming from these non-state actors, which we would never traditionally think needed a declaration. And I would say, if you look back at history, the United States has confronted opponents not like Al-Qaeda or terrorist groups, but that aren't states before on a consistent basis and never had a declaration or any other kind of congressional approval. So it didn't serve this dual function. So, of course, all of the wars against the Indians and the Indian tribes were never declared. And some of them were quite significant. It involved lots of troops over large periods of time. Pirates, so the Barbary pirates weren't really pirates. They were, this part of the world causes us so much trouble. It's the same place as well as Syria, Libya, they were actually provinces under the Ottoman Empire that had kind of become independent. And they were basically holding people for ransom. Jefferson sent the Navy against them. He didn't tell Congress about it. He told Congress that they were on a training exercise, actually. But he didn't ask for congressional approval. The United States sent thousands of troops into China during the Boxer Rebellion. We had tens of thousands of troops in Russia that tried to overthrow the Leninist revolution during the years after 1917. We have deployed lots of troops all over the world against non-state actors. No one ever thought a declaration. So it seems to me what that proves is that, at least in the way our Constitution is operated, and I think it's consistent with the British understanding before the Constitution, is that declaration was kind of a nation-state to nation-state formality that you engaged in after hostilities had started. So again, this goes to this first question too. As circumstances are changing, I think the Constitution is adaptable, and this just sets out these principles, but doesn't say we have to always have congressional approval beforehand, unless you read these terms from the 18th century to be much more expansive. It's not just a declaration of war, it's the right to authorize a war. My response to that is that the framers didn't use that language, and they could have, because they knew how to do it in this other provision and in other discussions at the time. They knew how to say authorize war, make war, levy war, and they chose not to. They just used declare war.
Brett?
And to either of our panelists here, or the professor, I guess I'm most interested in your view. I think it's fair to say you think that the president can unilaterally begin hostilities, but what does the scope of that power entail? So, argument ad absurdum, but if you had a president who said, look, we're going to go to war with Canada tomorrow, but to show them...
It's a great idea, by the way. We would have universal health care faster if we took over Canada.
We want you to, but to make that happen...
Actually, joking aside, that was the point of the War of 1812, was to take over... Yeah, yeah. Everyone has a right to a wooden leg. No, it was to take over Canada.
Roll out the main Lancers or whatever unit, and I want you to shoot 3 dogs tomorrow just to show them how serious we are.
Yeah.
The destruction of a citizen in the United States, the destruction of citizens' property. He says, and whatever the act is, he says, look, this is what I think we have to do as part of the war effort. So is there a limit on the scope of even if you think he can begin hostilities, is there a limit on the scope? And the reason I think it's important is because you start making war on enemies, foreign or domestic, what does it even mean? And where do you draw the line between that and then civilian policing actions, especially if it's on domestic soil?
Actually, I'm glad you raised the second point, because I wanted to actually make clear that my view on the presidency and domestic affairs is actually much more narrow than in foreign affairs. And I think the framers actually had a very different view of the presidency when it came. So, I'm not a defender, for example, of the president's order on immigration policy. And I don't think he's carrying out his duty to take care of the laws are faithfully executed. Actually, I think the interesting thing about the Obama years has been that he's actually using a lot of the vigor and energy of the executive in domestic affairs rather than foreign affairs. And in foreign affairs, he's kind of become more passive. To me, it's a kind of interesting upside down inversion of what the framers, I think, wanted to encourage the president to do. But that's something we could talk about another time. In terms of the scope, you're completely right. I mean, under the system that I'm describing, you could have a lunatic who was president who decided, I'm going to use force and I'm going to attack our allies, right? That he could use or she could use force in ways that the American people would not want, right? This is not just a hypothetical. I mean, there were times in our history when American presidents considered launching preemptive nuclear attacks on other countries like China, Russia, the Soviet Union, and seriously discussed it and had lengthy meetings about it. So that's always possible. It's not entirely clear to me that might not happen anyway under Alberto's system, because a president would just say, I have to launch a nuclear attack against Russia because they're about to attack us. It's self-defense. But I think that's a problem with any system, that there's that possibility that you'll have very bad people in charge. And I'm not sure whether a constitution can really protect us from excluding all possibilities of mistake and error or just lunacy. You could say that the system I'm arguing for gives more ability to that than the other system. I suppose that's true. My system would allow more mistakes to be made in the going to war and probably have less mistakes made not going to war. Which I should have mentioned this also with the last question. I think that's a bigger threat to our national security now than it was in the 18th century. Because in the 18th century, we were protected by the oceans and technology was so slow and less destructive. You could wait around for a long time and nothing bad would happen to the country. I think today, in today's world, and if you want to talk about the non-state actors or WMD, it's really the big change. It also involves cyber and robots. The big change is the amount of violence that lies in the hands of one person or a small group is now almost equivalent to what armies used to be able to hold. In that kind of world, I think the error we have to worry about is not acting, not the error of acting, because of the potential for harm.
And I'm sorry to follow up, but is that constitutional? Because it is two different questions.
What's
prudent and what's constitutional?
I think the Constitution allows a range of possibilities. I don't think the framers wanted to set one war-making process in mind, because they were, and they talk about this a lot during the frame, they are worried about the idea that if you give a lot of power to Congress, that it actually might make it hard for us to act, because Congress's legislatures can't predict the future. That was one thing they're very conscious of. And that so when it came to unforeseen circumstances, rapid change, technological development, that's why you have the presidency. A lot of countries don't have a presidency. A lot of countries have a parliament, and that's it.
But I do think that even in 2016, it is a good thing to clog the president's will in just deploying overseas. I think that modern presidents, have a tendency to want to use the U.S. military, okay? And to try to fix through military force whatever problems we face overseas, even when military solutions are not appropriate. And I think we have to draw a distinction between, on the one hand, use of force and war. And we can say, yes, the president has a lot of leeway in using force, whether it's in response to a small level threat that we may face overseas, or to rescue American citizens in danger. I mean, these are not things, Grenada, Panama did not put the United States security at risk, okay? These are smaller uses of force where there's leeway for the president as the conductor of foreign relations, okay, to use military force. But that's different from war. War is a big thing, okay? And we're talking about major use of force involving major resources, posing major risks. I think it's a very dangerous thing to put that decision in one person's hands. And even more so, John, today, when we have the risks of global war that winds up annihilating us as much as the enemy. And so I should say one problem with John's argument is, for some curious, weird reason, okay, the people who were closest to the Constitution did not agree with you. Okay? And you're saying, well, the Helvidius debates, you know, the Helvidius debates were only 10 years after the Constitution was drafted. You know, it's like us talking about things that were happening in 2006, you know, very recently. You know, Hamilton makes it very clear. Madison makes it very clear. They disagreed on many things, but they say, you know, this thing of actually putting the country, moving us into a war, having a war on our hands, however you want to describe it, and the language is very broad here, is something that should be done by Congress. And then we got the next generation that came after them. You know, you got John Marshall, but you also have Joseph Story, and you got Abraham Lincoln. I'm saying, okay, were they all wrong? Were they just Alberto Coll reading the Constitution in some kind of Jeffersonian way? Many of them were not Jeffersonians, okay? But they believed that this was a very sound principle and that the Constitution was pretty clear on that issue with regards, again, to major war. I mean, let me just, you know, John talked about the earlier Price cases. You know, there was a second set of Price cases as a result of the Civil War. And, you know, Justice Robert Greer, okay? These are his words, okay? 1863, okay? The president does not initiate the war, but is bound to accept the challenge without waiting for special legislative authority. Exactly. If we are attacked, the president responds. He makes it very clear again. He says, the president has no power to initiate, there we go, or declare war. It says initiate is there. To initiate war against either a foreign nation or a domestic state. He needs some congressional authorization. Now, when attacked, of course, and that was Lincoln's dilemma. Yes, the southern states attacked the United States. They attacked us at Fort Sumter. So yeah, the president could attack them. The president didn't have to wait. But there's just a fundamental problem here, which is that a lot of the people who are right next to that document, who were in those generations, would not agree with your interpretation. And I think the reason that we have become comfortable with a different interpretation is that, for all kinds of reasons, we are tempted by this desire for a very strong executive in foreign relations who can at will send us into these major wars. And again, I'm not talking about small operations, but I think we need to hold on to this principle. It's a very basic principle of free government. I'll grant you everything you want as far as executive power when it comes to, you know, drone attacks against enemy combatants. I'm on your corner. I think the president
Can I get that in writing?
Yeah, no, you have it in writing. I just debated Mary Ellen O'Connell from Notre Dame the other day, you know, and I was saying, yeah, the president can. These are people who have taken up arms against the United States. They're in foreign territories. He doesn't need anybody's permission. He can attack them with drones, and he certainly doesn't have to arrest them or put them on trial any more than we had to arrest American servicemen who went over, joined the Wehrmacht, and were in tanks on the battlefield. So, yes, I'm up for a very strong executive, but we got to hold on somewhere to this principle that says, look, when it comes to a very big thing, a big war, the president cannot do it alone. And if we don't hold on to that principle, I think we're headed intellectually for some major problems in the way that we can conceive what you call, very rightly, the struggling relationship between the executive and the legislative branches.
I think we could continue our discussion for quite some time. Unfortunately, we are out of time this evening. Thank you all for your questions. Please join me in thanking our panelists